Josh Swanson, Vogel Law Firm.
Josh Swanson with Vogel Law Firm. Thank you for joining us here today with the Crude Life Media Network, and a story we've been following now for, seems like it's going on well over a year, if not more than that, but it has to do with some mineral rights with some North Dakota landowners, as well as, I should say, some mineral owners, as well as the government, Lake Sakakawea. In the email earlier asking for an interview, I mentioned to Josh, I called it a kerfuffle. And so I'll let you kind of set the table for the listeners out there, the people who may not be familiar with this case that just kind of seems to not go away.
Yeah, the word you use, kerfuffle, I'm not sure how many letters are in that word, but I could think of some four-letter words that might be synonymous with kerfuffle that have maybe describe what this has become, and this deals with the mineral rights under Lake Sakakawea. And as folks in western North Dakota and oil and gas country know, and people that pay attention to these things, such as yourself, there was a Supreme Court decision, Wilkinson versus State, wherein my clients, the Wilkinson family, prevailed, where the Supreme Court ruled that if the state's going to claim the minerals under Lake Sakakawea, that's an unconstitutional taking, and they needed to provide compensation to the private mineral owners. Now, that decision came down this past September after the legislature passed Senate Bill 2134, which validated the rights of the private mineral owners who had that property under Lake Sakakawea before the United States government acquired it for Garrison Dam back in the 1950s. So now, part of what Senate Bill 2134 required was a new study commissioned by the Oil and Gas Division of the Industrial Commission to figure out where the ordinary high watermark line was. Now, fast forward to the last week of June 26th, Wank and Associates, the group that had done the survey, there was a public hearing and an opportunity for the public to comment on Wank Associates' survey of where the ordinary high water mark was. And what those public comments revealed was that there are some serious deficiencies with the Wank report, including constitutional defects that'll land the thing right back in litigation before the courts in North Dakota dealing with ordinary high water mark. Now, this is an issue that should have been resolved a long time ago. The North Dakota Supreme Court is very clear in the Wilkinson decision, and I can tell you, line and verse, paragraphs 21 through 25, that if the state tries to claim any acreage outside of the acres, let me restate that. If the state tries to claim any acres that private landowners reserved when the United States acquired the property for the Garrison project, that is an unconstitutional taking. The Wank Associates report flat out ignores that portion of the Wilkinson decision and says that there's 10,402 mineral acres owned by private landowners that Wank says the state ought to get, which is a clear violation of the Supreme Court's decision in Wilkinson. So, we had thought and hoped that that issue would be resolved by now, but it's the never-ending saga, and there just doesn't seem to be any finality to this thing.
Correct me if I'm wrong on the timeline, but there was a case where the private mineral owners had won that, and then the state went back and reopened it or re-sued them, or I don't know what the correct terminology is, but they didn't like it, so they went around and said it's our money. I guess, is that how I'm following this?
Well, the gist of it is, Jason, that if the state goes through and claims those 10,402 acres that the Wank survey says belong to the state, those acres were specifically reserved by private mineral owners, then they'll be ignoring the Wank decision, and this will end up in litigation. Now, as far as the timeline goes, back the last legislative session in 2017, mineral owners and industry got together and the legislature passed Senate Bill 2134, which says that the United States Army Corps of Engineers taking lines used to acquire property by the United States for Lake Sakakawea and the Garrison project, that those lines controlled, and those were the presumptive lines for determining ownership. So the state legislature got that part right. The problem now isn't so much with what the state has done, but with the survey group, Wank and Associates, who they hired to do the survey, who said the state owns those 10,000 acres in contradiction of the Supreme Court's decision in Wilkinson. So the issue we have now is that if the Industrial Commission adopts the Wank report as is, this thing will end up back in the court system, and we'll be litigating it again, even though the Supreme Court has already spoken to it. So we don't know yet what the Industrial Commission is going to do with it. Like I told them at the hearing for public comment on June 26th, they have an opportunity to get this right and avoid that result. And then it's my sincerest hope that they do that, because the last thing that I want, the last thing that my clients want, and frankly, the last thing the state needs is to keep throwing good money after bad and litigating this when the question's already been decided by the Supreme Court.
So what's been happening at a state level? I got an email indicating that there's been quite a bit of turnover, or a lot of different jostling around of it looks like different people that are on the case, not on the case. Attorney General's office removed several assistant attorney generals, that sort of thing. That was just an email I got that sparked, me to contact you, Josh Swanson with Vogel Law Firm, who's I guess the lead attorney on this. Would that be the right way? The lead attorney on this case?
Yeah, I think that's absolutely fair to say, Jason. We've been involved on this going back since February 2014 is when the case ended up on our desk and our clients. And it's not so much, me, the lead person fighting this. It's my clients who deserve the credit for taking on the state of North Dakota and the Land Board and the Attorney General's office. And if it wasn't for the efforts of folks like the Wilkinson family and Ed Lynch and Suzanne Vos, and other mineral owners wouldn't be reaping the benefits of their fight. And I've just been, the attorney for them on that part, but they're the ones that really deserve the credit. And to your question, your guess is as good as mine as what's going on in the Attorney General's office. The two assistant attorney generals who are employees of the state of North Dakota who were involved in this litigation from the beginning, I can't speak to their role in the case anymore, but what I can tell you that in the Nelson and Sorum lawsuit that Representative Nelson filed challenging the legislation, they're not the attorneys of record in that case. And in fact, the state is spending money on outside counsel, and they've hired two very capable attorneys in Dan Gossett out of Grand Forks and Mark Hansen out of Fargo, but they're both private practice attorneys. So it's unclear to me whether or not the Attorney General's office has tag team in two new private practice attorneys to handle that. But my concern with that is the fact that, when is this finally going to be over? As the state, it's unclear whether the Attorney General's office has abandoned their claim to these minerals under Sakakawea, and whether or not they'll challenge the findings of the Wank report if the Industrial Commission comes back and says, you know what, enough is enough. These private mineral owners have been to hell and back on this. The Supreme Court says they own the minerals. We're going to leave it alone. The Attorney General's office has not come out and indicated whether or not they'll agree with that position. So, what's so frustrating for my clients and myself, Jason, is, we thought that there was clear direction back last September, and when the legislature passed and the governor signed Senate Bill 2134 in April of 2017, yet we're on this never-ending merry-go-round where my clients and hundreds of other mineral owners can't get the royalty proceeds that are in suspense. So while their money is tied up and they can't get it, they're still having to spend money on attorneys to fight the state on this and fight for minerals that the Supreme Court has already said belong to them.
And that's the part that I was kind of going at about the different turnover and a few other things. I just, first of all, wanted to confirm that. And second, I'm going to tell you something that I'm hearing more and more involving the state of North Dakota, and you can editorialize if you want, or if your clients have made this comment, and that's actually the question, basically, have your clients made comments along this, or have you heard anybody that has done this, which is it's tough to take on the state of North Dakota a lot of times because, for one, they've got deep pockets. You know, they talk about budgets and everything else, but as you just mentioned, the Attorney General office seemed to have enough money to get outside counsel. And taking on the state as well, you have to be a little bit more civil, no matter how they act. There's this new thing called ghosting where they just don't call you back or don't return an email. And so people can get frustrated in a lot of different ways because you've got 47 different ways to contact people now. And when you're using all 47 of them and you don't get a response back, well, then you got to hire an attorney. And kicking the can down the road, and you know this, being an attorney, this is no news flash here, but the longer it takes to litigate, the more attorney fees get racked up. So when you talk about, you know, your clients have been to hell and back, I hear these stories a lot in other industries when you're dealing with the state. So just to describe that hell and back a little bit. I gave you a couple anecdotal ones, I guess, that basically have to deal with hemorrhaging money over time, that it just seems like if they wait it out, eventually the people will go away. So, you know, I opined way further than I normally do in the past, but as I said, I'm hearing this theme over and over and over again, and you're an attorney, so you can speak without getting sued, more or less. So go ahead. I'm sorry.
Yeah, and you know, I'll make this clear that we've got boots on the ground, and I represent, you know, dozens and dozens of clients in western North Dakota, and we're on the front lines in Williams County, in Montreal County, in McKenzie County, in Divide County, and when it comes to dealing with the state, the thing that we hear, just like you explained, is that they'll ignore requests. They'll be non-responsive. And in fact, one of the biggest frustrations for my clients is they were specifically told by the land board several years ago, a guy in a black robe meeting a judge is going to have to sort this out. Well, it should have never gotten to that point where they told taxpayers and citizens of our great state, folks whose parents and great-grandparents owned that property going back to World War I, whose aunts and uncles were shipped off to the front lines and landed on Normandy in Europe to fight back tyranny and oppression and save the world for democracy, while one of my clients was back home in Williston at 12 and 13 years old getting a license at the courthouse back in the 1950s so she could drive grain truck and help her folks on the farm. And these folks were stonewalled. They were treated with disdain and disrespect, and their only recourse was to go to the courts and spend hundreds of thousands of dollars on attorneys to fight the state and their elected representatives. And that's maddening as hell to me. As someone who grew up in Maddock, North Dakota, as a fifth-generation farm family, my dad and grandpa still farm there. I know how near and dear our property is to our family and to our hearts. For other North Dakotans and other folks to have to go through that, it really rubs me the wrong way. And I was speaking at a royalty owners conference in Bismarck the Thursday before the 4th of July, and I heard that same story over and over and over. Why is our state government doing this to us? Why do we have to spend all this money on attorneys to fight for something that has been in our family for generations? And the problem we have is there doesn't seem to be any answers. And when we've asked the questions, I know you and I have visited about this, and I visited about this issue with many other members of the news media covering it, we cannot get answers from the state on it. Now, on the one hand, I will say that at the hearing on June 26th in Bismarck at the Heritage Center, there is where the public comment hearing took place, the Oil and Gas Division seemed to be receptive to our comments and understand the gravity of the situation and the need to get it right this time. But I can tell you that we're going to have a complaint and a lawsuit teed up. So if they don't get it right, we'll file it right away and be back in courts. And what our hope is, Jason, that folks listening to your show and folks listening to other shows will join the fight with our clients, because there's power in numbers, and mineral owners should be in the ears of their elected representatives, but they should also be calling attorneys on this and trying to pool their resources to fight it, because when it's one person fighting this fight, the bill is tens of thousands, or in my client's case, hundreds of thousands that they've racked up in fees over the course of the last 4 or 5 years. But when you can divide that by 10, 15, or 20 people, the costs start to go down. But you're absolutely right, is that the state has thrown all kinds of resources at this, and we've had to fight like hell to make sure our clients' rights were protected and preserved, which they were. The North Dakota Supreme Court got it right. But I can tell you, in my office here at Vogel in Fargo, North Dakota, I'm looking at 3 giant bookshelves. Each of those bookshelves is filled with thousands and thousands of pages in binders dealing with this case that I've had to review, that I've had to digest and make sense of, which is money that my clients have to pay me. And I don't want more attorney fees on this. I want this to be done so my clients can have finality and move on with their lives. But we just haven't been able to get that from the state here.
Josh Swanson, Vogel Law Firm. Talk to me about some of these other groups. You mentioned the oil and gas industry seems supportive with the direction you guys are going, either through the language definition or the current status of what the Supreme Court decided in favor of the landowners, mineral owners before. But how about like the Petroleum Council or this landowners, mineral rights divisions and organizations? You know, there's probably 3 or 4 different organizations that would fall under this in terms of advocacy or any kind of outreach. Have you spoken to any other councils or organizations?
Well, what I can tell you, in the 1,500 pages of comments that were submitted to the Industrial Commission on this, the Petroleum Council and Ron Ness, they submitted comments pointing out several issues with the Wankin Associates reports. And I think those comments were spot on as well, pointing out the fact that the way the survey was set up, it doesn't match with how the Industrial Commission sets up its spacing units and determines, the different units for different oil and gas wells out in western North Dakota. The Public Land Surveyors Group, they put in extensive comments pointing out similar deficiencies. So I know that, the Petroleum Council, as far as both this particular survey and Senate Bill 2134, we worked alongside them on that, and they were good to work with. And I think they would share, I can't speak for them, obviously, but I think they share many of our same concerns. And I know that they put in briefing in the Nelson and Sorum lawsuits, and we're on board with the briefing that they've submitted there. But I can tell you, if you go and take a look at those, it's something like 1,436 pages of public comment. I think I've got about 450 pages of those submitted. But even the remainder of them, there's really not a favorable thing to say about the report that was prepared as commissioned by the statute. And what I should also point out, I mentioned throwing good money after bad. The state of North Dakota paid Wankin Associates, this engineering group, a group that is not based in North Dakota. They paid them almost $250,000 for this survey, and it's a survey where they, by and large, I think, have to go back to the drawing board and look at all these deficiencies with it. But that's another, we talk about attorney's fees and resources poured into this. That's another $250,000 that the state has expended trying to get something right that should have been right from Jump Street. So
what's next? Before we get into that, quick question for you on the opposition. What is their argument? Because from my understanding is that you guys have a land deed or a mineral deed. I keep saying land, I mean mineral deed back to the turn of the century, back generations, that sort of thing, that indicates it. And generally it's cut and dry. But is it just because the lake has flooded so much, or they've done the man-made flooding on it? I guess where's the state's the very quick version? Why do they think they own the minerals when there was a deed that was produced before?
Well, what I'm about to tell you is going to sound patently absurd and bizarre, but their position in our litigation and their position to date Now, behind closed doors, they may have changed that position. That has not been shared with me. It has not been communicated to me. So where the land board and where the AG's office falls on this, I think that's a question they absolutely need to answer. But their of-record position to date is that the government can flood private property and then claim ownership of that property without having to compensate the private land owner. That's in direct violation of Article 1, Section 16 of the North Dakota Constitution, and it flies in the face of the sacred protections of the Fifth Amendment of the United States Constitution. That is literally their position. I'm not exaggerating. I'm not embellishing. Their position in the litigation, and in this case to date, has been that because the United States flooded all that property for Sakakawea, somehow the state then owns the minerals underneath Sakakawea, even though, just as you indicated, those private mineral owners specifically reserved those oil and gas rights subject only to the United States' ability to flood the surface of it. The state is a stranger to title. The state has always been a stranger to title. The state has never had an interest in its property, and now they're Johnny-come-lately with their hand out asking for money because these private mineral rights are extremely valuable.
Boy, that's a slippery slope you just mentioned there, about the government can flood land.
You know, it's extremely scary, and the reason it's so scary, think about what's going on in the Red River Valley with the diversion here in Fargo, if that ever goes through. The extension, and we argued this to the Supreme Court in the Wilkinson case, the extension of the state's argument is that it can acquire the farmland, the rich farmland in the valley that would be subject to this diversion around Fargo, that the government can flood that and then somehow claim they own it without compensating the landowners. And that flies in the face of the Fifth Amendment. It flies in the face of the North Dakota Constitution. And it doesn't take a constitutional scholar to point that out and to be able to understand what is so wrong with that, what is so offensive about that.
You know, and to me, it reminds me a lot of the strategy that was used with KELO versus, I believe, New London is the landmark case for economic development, where they said a government or a private company through a government can come in and call eminent domain on some private land, that sort of thing, for economic development. And, of course, now we look at it 20, 30 years later, and a lot of those mega malls are empty. So I kind of chuckle at that a little bit, but it kind of reminds me of that slippery slope a little bit, you know, which probably had some good intentions in the beginning, but boy, it certainly gets stretched in the, very one-sided in the end. It becomes very stretched, it seems like.
Yeah, and that particular case, that's one of the more recent, the most recent U.S. Supreme Court decision on the Fifth Amendment, KELO versus City of New London, decided back in 2005 by the Supreme Court. And you're absolutely right. It was a 5-4 decision, but the idea that the government can take private property and use it or claim it to public use for economic development purposes. I mean, we're talking about this right now. One of the big issues that's going to come down later today, and we're going to hear about for the rest of this week and the rest of July, and maybe even the rest of the summer with the midterm election, is the president's nomination to replace Justice Kennedy on the Supreme Court. So in that context, you know, Roe v. Wade gets all the attention on this, but things that have such an impact on North Dakota landowners and citizens, like the takings issue, it's critically important, whatever nominee it is, that they get it right, because there was a lot of criticisms of the decision in the KELO case because of the idea that the government can take private property for economic development and rezone areas in that regard. I mean, as someone who grew up here, to me that's offensive. You know, someone should not be able to take any private property, but particularly farmland and minerals that have been in some families for generations, and then claim somehow that the government owns them. I mean, it may sound, the reality of it is when the founding fathers and the framers got together and they had the Constitutional Convention, the Articles of Confederation aren't working, they scrap that, they enact the Constitution's ratified. The Bill of Rights were the first 10 amendments to the Constitution. Those were the protections put forth because our framers recognized the dangers in giving government too much power and the arbitrary exercise nature of that power if exercised by the government, that there had to be a limitation on those rights. And one of those protections, the most sacred rights that we have as citizens of our country, is in the Fifth Amendment that protects our private property from being taken by the government. So, the North Dakota Supreme Court, to their credit, they understood this. They got it right. They got it right in the Wilkinson decision. And the fact that there seems to be so many individuals in the state government that haven't grasped that and can't understand that. Like I said, the last thing I want to do is relitigate this to the Supreme Court. But like I told the Industrial Commission, that if they don't change this Wenck report, if they adopt it as is, they are rolling out the red carpet for litigation, and there will be litigation.
So what's next for people that have mineral rights that are experiencing some pressure or changes, or even next for these folks that are experiencing the current pressure they're under? What's next for these mineral folks?
Well, my understanding is there's an emergency land board meeting this Thursday, July 12th, and whether they'll come out with some sort of public position on this and take a stronger line. Land Commissioner Smith, she did testify Tuesday the 26th on the hearing, and she has some concerns that she expressed on behalf of the land board. And I'll say that, by and large, she's been a breath of fresh air to work with on this. I don't want to relitigate past issues we had with the former land commissioner. I think those are well documented in our litigation. But my interactions with the new land commissioner seem to indicate that she understands the gravity and seriousness of what's going on. But I'm very curious to see what comes out of that land board meeting on the 12th of this month here. But the other end of it is, Jason, I think there needs to be, whether it's the governor or the attorney general, they need to come out and make clear what their position is on this and take a firmer stand for the rights of private property owners. Because I know, talking with every day, just like you, every day I'm talking to folks on the front lines. I'm talking to mineral owners. I'm talking to landowners. And I had one woman come up to me crying out in Bismarck at the Royalty Owners Conference last Thursday in June, because it destroyed her dad. When the United States took the property for Sakakawea, it destroyed her dad, because that farmland had been, he came over here, that was his pride. It was literally a part of his family, and it just crushed him when the United States took it. And now there's insult to injury, where they're still not getting paid for their private mineral rights, and they feel like they have to fight this battle upwind. And it would just be refreshing if someone with the political clout and wherewithal stood up and pounded the table and said, enough is enough. Let these private mineral owners get on with their lives. But so far, that they've been there monitoring it. They've been at the hearings, but they haven't come out publicly and said this needs to end.